After identifying the absolute competency of the administrative law court, then we have recognized what kind of cases we could bring to the administrative court. So now the next question is to identify the relative competency. For example, let's say I am a staff of the governor. I am a staff, but then the governor or maybe the institution terminate me from the position, or they fired me, they sacked me. But I think after I analyze the decree that they issued to terminate me from my position, I think the decree violates the law, so I'm going to violate. Maybe I consider that the procedure is not following the law. The law said I have to be given some coaches and also some warning before I am fired, but they just fired me without any warning. So I think it's misprocedure. So I'm going to fight this decree, the decree that issued by the institution or the officer. So I have to identify first where should I bring this case. This question is talking about which court has the authority to settle this case. So for us, we are identifying which court has the absolute competency to settle this case. After I make my analysis, so I can get into I get to the conclusion that this case is the authority of the administrative court, because it's between a government body or officer versus me, a natural person, and this problem occurred because the institution or the officer issued a decree that bring disadvantage to me. Okay, so that's the first step. So then, if I want to fight it, where would I bring it? Right? So I know this is the administrative court authority, the absolute authority. But then, where should I go? Should I go to the administrative court in Jakarta, in Malang, or where? Let's say that I am in Cikarang, but then the termination decree is issued by the governor, which is in Bandung, for example. Or maybe you are a civil servant and the decree of the appointment you as a civil servant is issued by the central government in Jakarta, but you are a civil servant in Kalimantan, for example. But then the central government in Jakarta issued a decree that the content of the decree is to fire you. So you are in Kalimantan. The one who issued the decree, or the pejabat tun or badan tun here, badan tata usaha negara, or the governance official or body here is in Jakarta. So you are in Kalimantan, the institution or the officer in Jakarta. So where would you settle this case? Would you go to the administrative court in Kalimantan or in Jakarta? So it's talking about the relative competency. So how to identify the relative competency of administrative court? So you can see it in Article 54, Administrative Court Law. It mentioned that the first one, to identify the relative competency, first you submit the lawsuit to the domicile of the defendant. So if your defendant is in Jakarta and you are in Kalimantan, so you submit the lawsuit in Jakarta. Or the second one, in case that the defendant is more than one party, so you can submit it to one of the territory of the defendant. Let's say that the defendant is the governor in Jawa Barat, and the other defendant is the capital government in Jakarta. So you have two defendants here. Let's say that the decree is issued by the two of them. So you can submit it whether in Bandung or in Jakarta. The third one is at the domicile of the plaintiff, but then the court where you live will proceed it to the place of the defendant. It could happen for a certain reason, but it would make the procedure be longer, because it would take time, because the first application will be issued to the place where you live, and then it would be continued to the place of the defendant. But it could be it's to cover the situation when the distance between the defendant and plaintiff is too far. The third one, it could be regulated based on the government regulation. It's to solve a certain situation, especially in emergency situation, maybe in a war, maybe in the condition of a force measure. It could be, but as long as there is a government regulation about it, it could be. Or maybe just like now, when there is a coronavirus, so people are not allowed to go out, maybe there would be some government regulation that the submission of the lawsuit can be submitted at the place of the plaintiff, even online maybe. The fifth one is talking about what if one of the party is living abroad, or let's say that you are going to submit a lawsuit against the decision of a certain embassy abroad, the officer of Indonesian embassy abroad. So you can submit it to PT UN Jakarta. If the place of living of the plaintiff and the place of the living of the defendant is both abroad, while if the place living of the defendant is also, if the place of living of the plaintiff is abroad, and the place of the defendant is in domestic in Indonesia, so the lawsuit could be submitted at the place of the defendant. Let's say that you are in Malaysia maybe, but then you want to sue the decree of a certain Indonesian institution, the government or officer, so you can submit it to the place or the legal territory of where the institution is located. So that is how you try to determine the relative competency of administrative court. Different court, different way of determining the competency. In case of administrative court, Article 54 is the one you have to understand, especially for you to be a practitioner one day. This is your guidance when you try to settle the case you are handling. To conclude, absolute competency is talking about the authority, while relative competency is talking about where or which court, in what province, in what district the case will be settled by the authorized court. In this case, it's administrative court. Especially in administrative court, the absolute competency and the relative competency has been regulated in administrative court law. So this is the end of this first session. At the second session, we will discuss further about the administrative court procedure in brief. Hope you still focus. Quite tough. Cheer up. Thank you.